What now?
Are you gonna send me downstairs like I'm the one making the noise or not? You don't know who was back there talking. I wasn't the only one talking.
Okay, right out the gate, we've got some heat in the courtroom. She's calling out the system before the judge even gets a word in. But here's the twist. Courtroom conduct matters a lot, and how you speak to a judge or bailiff can shape the rest of your hearing. Would you risk your case to speak your mind like that? Let me know.
Well, first and foremost, the bailiffs, the sheriff's deputies who are operating as bailiffs are the ones who control that pod there where the prisoners are kept. So the only thing that I know is that there was noise being committed, and we were almost through with the females, so they indicated they were going to transfer you downstairs. And since we were not going to get to you before lunch, I didn't see any reason that couldn't happen. So the other issue that I would have addressed is that you are here today. One of the motions that you have is a transcription. You are asking for a transcript and all judgment papers, and that's necessary for your appeal, and we'll deal with that. But the first and foremost thing is the motion to withdraw your guilty plea. In the case that we tried last week, you had pled guilty to the driving on a revoked license. So if you want to address that issue, then I'm going to let you take up each one of your motions. I have a motion to withdraw your guilty plea, a motion to continue the sentencing, a motion for a transcript and all judgment papers, and a motion to compel evidence, including copies of YouTube videos. So we're going to take those up in that order. So if you'll come to the podium, I will hear what you have to say on each one of those motions.
All right, what was the first one again?
First one is your motion to withdraw your guilty plea. At the trial, you were charged with driving on a revoked license, third offense, and then count 2 was dismissed and count 3 was retaliation for past action. Prior to the commencement, well, actually when the indictment was read, you entered a plea of guilty to count 1, driving on a revoked license.
Quick legal insight. Withdrawing a guilty plea before sentencing? Totally allowed, if the judge agrees. It's not automatic. The key argument here? The defendant says he was pressured by his elbow counsel. That's the court-appointed standby attorney when someone represents themselves. Risky move, but sometimes it's all you've got.
Defense. So that waived your right to contest the issue of whether you're guilty or not guilty of that. Obviously, there's not been a sentencing hearing on that, so you would still have the right to appeal whatever sentence I impose in that case, but you would have waived your right to contest your guilt or innocence of driving on a revoked license.
I object. The rule states that you can place a withdrawal of guilty plea before sentencing, and we haven't even been to sentencing yet. So that I'm well in the rights to withdraw my plea to guilt. I was under the pressure of my assistant counsel, and I feel like that he gave me some bad advice, and to withdraw is well in my right to do so.
Well, it is within your rights to request to withdraw your guilty plea. It is not an absolute right. You have referred to Rule 32, and I'm going to let the state just address these motions from the chair where she is, so that you don't have to keep walking back and forth. But I will let you address each one of those motions, and then I will let the state address those motions, and then I'll make my ruling. So that was your argument, is that you want to withdraw it because you think you got bad advice from Mr. Spratt?
Yeah, and it's just the pressure of my first time doing this, Your Honor. I fully didn't understand what was going on. There was a lot of other things going on at the time. I was doing my best to keep up, and that was like a spare moment decision.
This part right here is a textbook example of why transcripts matter in appeals. Without that paper trail, dates, statements, objections, you're flying blind. He's trying to buy time to build a motion for a new trial. Smart? Maybe. Strategic? Definitely. But the judge's patience may be running thin.
Okay. I understand. Let's move on to the second one. You have filed a motion to continue the sentencing in your case. Your motion to continue sentencing states that you're requesting a continuance in the sentencing, that you want time to prepare some preservable rights for appeal, and that the delay is only requested to receive the transcript from the trial. All right. I understand. Is there anything you want to add to what you've written there?
Yeah, basically, Requesting for a continuance because I plan to put in a motion for a new trial, and without the facts of the dates and the circumstances, what he said and she said, I mean, I couldn't give you a good, well drawn up motion for new trial to properly preserve for appeal.
All right. You want to request a transcript of the trial, is that correct?
Yes, I want a transcript of the trial, and I want any and all papers filed in by myself and the public defender and my paid attorney. This is not the first time I've put this into the courts. It goes along with filing for new trial. There's due process errors and other errors that the record can show, and it's in the possession of the courts.
Right. Then I will hand you a copy, Madam Clerk, if you will raise your right hand. You solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God. That is a motion to compel evidence, and you state that you want copies of you want all YouTube videos to be made available on USB or playable DVD or CD from the date of your arraignment to date. Those videos are relevance to your appeal. All right. Anything you want to add to that?
It stands for the same reasons that for all papers, to your honor, the same exact reason.
Okay. If that's all you have to, if there's anything else you want to add to those motions, that's what we're hearing today.
Is that I guess that she said it was all from, that's all from arraignment date?
I'm sorry?
Is that all from arraignment date?
Everything in your file, that would start with the arraignment and come forward, yes.
Okay.
Let me, before you leave the podium, you had previously made reference to and filed a motion for a speedy trial in your cases, and I'm prepared to give you a trial tomorrow on the on the failure to appear case. That is one of the three remaining charges, and I'm looking at a date later in the month for the trial on one of the other remaining charges so that we may comply with your request for speedy trial.
Let's pause. This defendant is staring down 3 different criminal cases. We're talking aggravated assault with a weapon, false imprisonment, even possession by a felon. And yet, he's still fighting for transcripts and fair treatment. Here's a real question. Does the system give pro-SE defendants a fighting chance? Or is this just survival mode in court?
What are the 3 remaining charges, Your Honor?
You have docket number 2021 CR 462, which is aggravated assault. Count 1 through 6 is aggravated assault while displaying a weapon. Count 7 is reckless endangerment using a deadly weapon. Count 8 is reckless endangerment with a deadly weapon involved. Count 9 is possession of a firearm by a convicted felon. Then the case 336 is the one we tried, and that's the one we've dealt with so far. Docket number 337 is count 1, simple assault, count 2, false imprisonment, count 3, disorderly conduct, count 4, public intoxication, and docket number 2024 CR 142 is a single count of failure to appear. So that is the case that I understand the state can be ready to proceed on tomorrow, failure to appear.
Okay.
All right.
Yeah, I'll be ready for that. I do have a request of the courts, though. I still have some video evidence at the jail. And
Video evidence of what?
Of the discovery that was in my discovery packet at the jail, and they're under the impression that I don't have any more court. When I asked to view it, they're telling me no.
Well, they'll be notified that you've got trials coming up. The trial tomorrow is a failure to appear, which shouldn't have any video evidence that would.
No, that's understandable, Your Honor. I don't understand where they're getting their information that I'm through with courts, and it's hindering me to be prepared when I come to court.
But we'll make sure that the bailiffs relay to the jail and that the clerk relays to the jail. You do have other cases pending. State is trying to determine whether or not they can have a trial on the 23rd and 24th of any of the remaining charges. Let me advise you that The trial that we're going to have tomorrow on the failure to appear will be by jury, but it will be a different panel they won't be the same jurors. In other words, they won't know anything about your prior case. So we have 4 panels of the jury group that was brought in. Group 1 was their first trial. Group 2 will be our panel 2, as we call it, will be the panel that will try your case tomorrow.
It would be the ones that was left over?
No, they weren't here that day at all.
Okay.
So they weren't brought in. We bring them in groups, panels. So the ones that'll try your case tomorrow will be a different group.
Okay.
All right. He needs to make sure he has his dress clothes to be able to dress in tomorrow. So.
Okay. Are we going to make a ruling on the rest of the motions today, Your Honor?
I'm going to make a ruling on your motions today after we hear from the state.
Okay.
All right. Thank you. If you'll have a seat.
Okay.
Judge, on the motion to withdraw guilty plea, I searched for case law that was on point where a plea was entered in front of the jury, and there's not a lot out there. I did not find a single case with those specific facts. I did find, and of course it is my duty to tell the court any case law that I find that is against my interest. There is substantial case law that talks about how the defendant must be notified of all his rights in a waiver and waive them knowingly and voluntarily and say that on the record. I don't think we did a rights waiver in this case, and so I leave it to the court's discretion if that would be reason for the withdrawal of the guilty plea. Based on how you rule on that, with the sentencing, normally the defendant would not need to file a motion for new trial until after the sentencing. So I don't know that he needs transcripts before we do the sentencing, only before he would file a motion for a new trial. So the state would be ready for that when the court chooses. And then you have handled the other 2 motions on your own, unless you want me to address either of those other 2.
That's all right. Just wanted to give you an opportunity if you want to be heard.
Thank you, Judge.
All right, on the motion to withdraw the guilty plea, there isn't, as General Bryson points out, any clear direct evidence or case law on the point.
Plot twist. The judge actually grants the motion to withdraw the guilty plea. That's huge. Most judges don't backtrack unless there's a major procedural issue. But here, the judge admits, yeah, maybe they should have paused the trial and clarified the plea rights. It's a rare moment of judicial humility, and now we've got another trial coming.
The defendant was representing himself with elbow counsel, and for that reason, he was given some specific advice. Now, he argues that the advice given to him by his elbow counsel was, in fact, not the appropriate advice, or it was not sufficient because he did not realize that he could not appeal according to his motion, he said he did not realize he could not appeal from that guilty plea. Well, he can appeal the sentence imposed, but he cannot appeal the finding that he's guilty of driving a revoked license. But because of the fact that essentially Mr. Vaughn is arguing that he was not fully aware of his rights, and because, as the state pointed out, normally this is done prior to trial with a what we call the Mackey rights, where I explain all of the rights and go through that litany of rights that they have prior to accepting the plea. The only other option would have been to have suspended the reading of that indictment to the jury and his response, send the jury out of the room, and then conduct that. And probably that would have been the better practice. So I'm going to grant his motion to withdraw his guilty plea as to that driving on a revoked charge, and we'll place that back on the docket in a separate, it'll be tried separately than anything else. So essentially, you're going to have a separate trial on that charge. The motion to continue your sentencing, I'll grant that as well, so that you have time to be able to do whatever. When did we set the sentencing hearing, Madam Clerk? Do you remember? We have not. All right, we'll set it in January then to give him sufficient time. That ought to be more than enough time. sentencing hearing will be on January the 28th at 1 o'clock.
You write this down for me. You can flip that paper over right there.
Then the next motion is for a motion for a transcript and all judgment papers, which I have supplied to you. And then the last motion is a motion to compel evidence, which is arguing that you should be entitled to a download of all YouTube videos. This court finds that those YouTube videos are in the public domain. They are not evidence that was utilized in the trial of your case. And for that reason, this court does not find that there is any obligation on the court or the state to download and go back through and every hearing that you've had. You have a right to transcripts of hearings if it gets to the point where you are going to ask for a transcript of the proceedings, but you do not have a right to a broadcast of the proceedings on YouTube. The transcript of the evidence would be sufficient to show what happened in court. The Court of Appeals does not consider a YouTube video. They don't watch videos when they consider an appeal. They refer to the written transcript and the exhibits. So your motion as to the YouTube videos being compelled to be brought before you, I am denying that motion. That concludes all of the motions that were set before the court. We have determined that we're going to try the case of failure to appear tomorrow to a jury. So we will allow you to resume. You still want to represent yourself?
Of course.
Okay.
I do have a question for you.
What is that?
Mr. Lee Spratt continued to stand up on my trial day, and he made the statement about not being paid to do so. Well,
Correct.
From my studies and what I was looking up, it stated that over in the I can't remember the rule exactly, but it stated that all appointed attorneys were paid. Is there any knowledge of yours?
Yeah, I can tell you that he was not appointed as the attorney of record for your case. He was designated as advisory or elbow counsel. There's a difference. His obligation is not to represent you in the case and to, handle the trial. He is there only to answer questions or to give you suggestions. So as a result, it is my understanding and my belief that that he does not get paid for that. And so for that reason, as I pointed out earlier, advisor, you've elected to waive your right to have counsel represent you. And I've reiterated that question to you on more than one occasion. And again today, if you want to represent yourself, you have indicated, of course, so you plan to represent yourself. By saying that, you are waiving your right to have an attorney represent you.